PVL3701 Property Law Study Unit 12 Mineral Rights. Number 1. Introduction. In this part, we discuss the meaning of the concept mineral and mineral rights. The Mineral and Petroleum Resources Development Act No. 28 of 2002, the MPRDA, which came into effect on the 1st of May 2004, declared the state custodian of all the petroleum and mineral resources in the Republic of South Africa. This act abolished the concept of mineral rights and provides for the regulation of the rights to prospect and mine for minerals. In the paragraphs below, we explain the meaning of the word mineral, refer to the concept mineral rights as it existed before the promulgation of the Act, and very briefly discuss a number of important provisions of the Act. Number 2. Meaning of concept mineral. The word mineral can have different meanings. In a very broad sense, it refers to all substances in the Earth's crust that are neither of vegetable nor of animal origin. Scientifically and technically, the word mineral may refer to an inorganic substance having a definite chemical composition and possessing certain characteristics easy to define. In a popular and narrow sense, the word mineral refers to everything that is usually regarded as a mineral in common parlance. This would normally include substances such as sand, stone, and clay. Please note that the MPRDA includes sand, stone, and clay in the definition of a mineral. See the definition below. To determine the correct meaning of the word mineral in a particular instance, it is important to distinguish between the different contexts in which the word is used, and to determine the intention with which the word was used by the parties to a contract or by the legislature in a particular statute. The intention of the parties to a contract has to be ascertained from the contract as a whole. In the absence of indications to the contrary, it will be assumed that the parties intended the word mineral to be understood in its ordinary popular meaning. Even if a mineral is defined in a statute, it may, in certain circumstances, still be necessary to ascertain from the statute as a whole whether the legislature intended a particular substance to be included as a mineral as defined in the statute. The Mineral and Petroleum Resources Development Act No. 28 of 2002 defines mineral as follows. Mineral means any substance, whether in solid, liquid, or gaseous form, occurring naturally in or on the earth, or in or under water, and which was formed by or subjected to a geological process, and includes sand, stone, rock, gravel, clay, soil, and any mineral occurring in residue stockpiles or in residue deposits, but excludes A. Water as a carrier of minerals, B. Petroleum, C. Peat. Okay, and then we move on to number 3, mineral rights. Number 3.1, common law. At common law, the owner of land was also the owner of all the minerals in the land until the minerals had been extracted or separated from the soil. The owner of land, as owner of the minerals, was also the holder of the mineral rights in respect of the minerals in the land, except where the rights to certain or all the minerals had been reserved or transferred to another. A mineral right entitles the holder to enter upon the land and to prospect and to mine for minerals. Mineral rights could be severed from the ownership of the land by issuing a separate title of rights to minerals to the owner of the land, or by means of a notarial cession, transfer of mineral rights to another. Furthermore, mineral rights could also be expropriated. Mineral rights, often referred to by the courts as quasi-servitudes, were generally regarded as a class of unique real rights, sui generis, comparable to servitudes, although they differed from servitudes in many respects. In Agri South Africa versus Minister of Minerals and Energy 2013, the Constitutional Court described the common law mineral rights as a limited real right providing the holder thereof with the entitlement to enter the relevant property, search for minerals, and sever and remove minerals so found. Number 3.2. Mineral and Petroleum Resources Development Act No. 28 of 2002. The legal position regarding the extraction of minerals has changed significantly with the promulgation of the Mineral and Petroleum Resources Development Act No. 28 of 2002. Section 3 of the Act vests all mineral and petroleum resources in the state to be held by it as custodian for the benefit of all the people of South Africa. In effect, the common law rule that the owner of the land is also the owner of all unsevered minerals in the land has been abolished. The Act does not stipulate that the state is now the owner of all minerals and petroleum, and the matter is open to interpretation. The Act contains no definition of mineral rights but provides for and regulates prospecting rights and mineral rights. Prospecting rights and mining rights must be applied for, and these rights may be granted only by the state. The exercise of these rights, as well as the maximum exploitation and utilization of minerals, is fully controlled by the state, subject to certain transitional measures contained in the Act. Existing old order prospecting rights and old order mining rights, including common law mineral rights, terminate if not converted into new order rights within the prescribed transitional period. Unused old order prospecting rights and mineral rights will expire if the holders of these rights do not apply for new order prospecting rights and mining rights during the prescribed transitional period. The transitional period has lapsed. The conversion and granting of these rights and their continued existence depend on compliance with the provisions of the Act and the discretion of the Minister of Mineral Resources. The Act states that prospecting rights and mining rights are limited real rights in respect of the mineral or petroleum and land to which the right relates, yet they may only be transferred with the written consent of the Minister. The content of a prospecting right and a mining right, as well as the duties of the holder of each right, are circumscribed in the Act. Applications for prospecting rights and mining rights have to be lodged in the prescribed manner at the office of the regional manager of the Department of Mineral Resources in whose area the land is situated. A prospecting right and a mining right become effective and therefore vest as limited real rights on the date of approval of the environmental program required by the Act. Approval of the rights must be lodged for registration at the Mineral and Petroleum Titles Registration Office within 60 days after the right has become effective. A prospecting right is granted for a specified period that may not exceed 5 years and may be renewed once for a period not exceeding 3 years. A mining right is granted for a specified period not exceeding 30 years and may be renewed for further periods, each of which may not exceed 30 years at a time. The Act repeals the provisions of the Deed Registries Act No. 47 of 1937 pertaining to the registration of mineral rights. The registration of mineral rights and prospecting contracts in the Deeds Registry has therefore been abolished. And then you can just study diagram 26 pertaining ownership of minerals on your own time. And then on the next page, there's also an activity. And then we can move on to water rights on page 249. Number 1. Introduction. Prior to October 1998, the rights of water and water use were mainly regulated by the Water Act No. 54 of 1956. This Act retained the common law distinction between public water and private water. Although it regulated the use of water, it acknowledged the private claims of riparian landowners to public water and those of all landowners to private water. The National Water Act No. 36 of 1998, in declaring the state to be the trustee of all the water resources in the Republic of South Africa, brought about significant changes in the legal position pertaining to the access to and use of water in the Republic. With reference to the Water Act No. 54 of 1956, we shall briefly discuss a number of important provisions of Act No. 36 of 1998 in the paragraphs below. The paragraphs below contain a brief discussion of a number of important provisions of Act No. 36 of 1998 and include references to the Water Act No. 54 of 1956. Number 2, the Water Act number 54 of 1956. The Water Act number 54 of 1956 consolidated previous legislation pertaining to water. It retained the common law distinction between public water and private water. These two categories of water were defined for the purposes of the Act. Number 1. Public water. There was no right of ownership to public water, as per Section 6, Subsection 1. The control, use, and enjoyment of public water were comprehensively regulated by the Act. And number 2, private water. Section 5, Subsection 1 of the Act provided that the sole and exclusive use and enjoyment of private water belonged to the owner of the land on which such water was found, but that such an owner could not, except under the authority of a permit from the minister and on such conditions as may have been specified in the permit, sell, give, or otherwise dispose of such water to any other person for use on any other land, or convey such water for his own use beyond the boundaries of the land on which such water was found, as per Section 5, Subsection 2. Under the circumstances described in the Act, an upper owner also had to allow a lower owner the use of a reasonable share of water that arose on the land of the upper owner. And then number 3, the National Water Act number 36 of 1998. Number 3.1, General. The Act, which came into operation on the 1st of October 1998, repealed and replaced all previous legislation dealing with water. The use of water is currently regulated by 2 statutes only, namely the National Water Act No. 36 of 1998 and the Water Services Act No. 108 of 1997. Number 3.2, Purpose. The National Water Act no longer recognizes the distinction between public water and private water. The purpose of the Act is to ensure that the nation's water resources are protected, used, developed, conserved, managed, and controlled in ways which take into account various factors so as to meet the basic human needs of present and future generations. To promote equitable access to water, to promote the efficient, sustainable and beneficial use of water in the public interest, to protect aquatic and associated ecosystems and their biological diversity, to reduce and prevent pollution and degradation of water resources, and to manage floods and droughts, as per Section 2. Number 3.3, State as Trustee. Section 3, Subsection 1 to 3 of the Act provides that the state, as trustee of the nation's water resources, must ensure that water is protected, used, developed, conserved, managed, and controlled in a sustainable and equitable manner for the benefit of all people and in accordance with the Constitution of the Republic of South Africa, 1996. To this end, the state is empowered to regulate the use, flow, and control of all water in the Republic of South Africa, as per Section 3, Subsection 3. The Minister of Water and Sanitation is ultimately responsible for ensuring that water is allocated equitably and used beneficially in the public interest, while at the same time environmental values are promoted, as per Section 3, Subsection 2. And then you can just study diagram 27 on your own time, as well as the activity that follows on the next page. And then we move on to the next part on page 253, the leases, the tenants' rights. Number 1, Introduction. Many South African cases confirm the rule, hier gaat voor koop, lease overrides sale. We indicated above that a lease contract creates personal rights, that is, creditors' rights or claims, for the parties to the contract. You can see Study Unit 2, Paragraph 1 in this regard. These rights cannot be enforced against third parties. In Roman law, this meant that a new order of the leased property could evict the tenant from that property. In Roman Dutch law, the rule lease overrides sale was introduced and the leasee acquired a limited real right against a subsequent purchaser of the land. This rule entails that a lessee is protected in certain circumstances against a new owner of the leased premises. Since this rule also applies in South Africa, we shall proceed to determine its scope. Number 2. Applicable only to houses and land. The rule hier gaat voor koop, developed out of the medieval use of land. Consequently, it originally applied to leases of houses and land only. The rule was later extended to cattle, and it is generally accepted in modern law that the rule should extend to all movable things. Number 3. Establishment of lessees, the tenant's real rights. Between the lessor and the lessees, inter partes, the mere contract offers sufficient protection to the lessee. The lessee can enforce his or her personal rights against the lessor, even if he or she is not in control, that is, possession, of the premises, and if his or her right has not been registered, depending on whether we are dealing with a short or long lease. However, control or registration is a requirement for the establishment of the lessee's limited real rights. Number 3.1. Long leases. A long lease is a lease for 10 years or more. In Roman Dutch law, registration was a requirement for the establishment of a lessee's real right in this case. An unregistered long lease was also valid for the full term against the lessee's successors who had notice of the lease. Even if the lessor's successor had no knowledge of the existence of the lease, the lessee was still protected for the first 10 years of the lease, provided that he or she was in control of the leased property. Furthermore, an unregistered long lease was valid for the full term against universal successors in title in terms of a will. Successoris universali. In contrast to particular successors in terms of a gift or donation. Successoris singulari. In South African law, this distinction fell away, but now a distinction is drawn between successors under lucrative title, successores titulo lucrativo, and successors under honoris title, successores titulo honorosa. Okay, please forgive my pronunciation. The former category refers to persons who do not give value for the acquisition, for example, a donation, and the latter to persons who acquire for value, for example, who buy the property. In other words, the position regarding a long lease before the commencement of Section 2 of the General Law Amendment Act No. 50 of 1956 can be summarized as follows. Number 1. Successors under lucrative title were always bound to the lease for the full period thereof. And number 2. Successors under honoris title were bound. A. For the full period of the lease if the lease was, firstly, registered against the title deed of the property, or secondly, not registered but he or she knew of the lease, or B. For the first 10 years of the lease, if the lease was not registered and the successor under honoris title did not know of the existence of the lease, provided that the lessee was in control of the leased property. The law on this point became somewhat confused when the legislature enacted Section 2 of the General Law Amendment Act No. 50 of 1956. The section simply provided that no long lease would apply against the successors of the lessor unless it was registered against the title deeds of the leased property. In Expropriation versus Aesop 1970, the Appellate Division held that the common law was not amended by Section 2 of Act No. 50 of 1956. The position as explained above therefore prevailed. In the meantime, Section 1, Subsection 2 of the Formalities in Respect of Leases of Land Act No. 18 of 1969 replaced Section 2 of Act 50 of 1956. The new section, like its predecessor, applies to long leases. It regulates leases entered into for a period of at least 10 years or for the natural life of the lessee, or another person mentioned in the lease, or which from time to time at the will of the lessee are renewable indefinitely or for periods which, together with the first period, amount in all to at least 10 years. Section 1, subsection 2 determines that no long lease shall be valid against creditors or successors under onerous title of the lessor for a period of longer than 10 years. Number 1, unless it is registered, or number 2, or the creditor or successor had knowledge of the lease. This section has eliminated the uncertainty arising from the 1956 Act, and the position existing before 1956 has been re-established. Number 3.2, short leases. Number 3.2.1, general. As we indicated above, a short-term lessee who is not in control obtains a personal right only. He or she can enforce this right against the lessor but not against any third persons, such as purchasers in good faith. In the case of a short lease, the lessee's limited real right vests when he or she obtains control. Where the purchaser has had actual or constructive notice of the lease, the lessee is protected, even though he or she is not in control. Number 3.2.2, gratuitous and onerous successors. All short-term lessees who are not in control under an unregistered lease may maintain their lease against gratuitous successors of the landlord, even if they do not have notice of the lease. They can maintain their lease for the original lease period. They cannot maintain the lease against onerous successors. And then you can just study diagram 28 on your own time. Number 4. The effect of the lessee's or tenant's real right. It should not be concluded from the maxim lease overrides sale that it is only the buyer's right that has to give way to that of the lessee. The maxim applies to the rights of anyone who has established rights to the thing after the lessee's rights has been established. Reference to sale is only a specific illustration of the fact that the lessee has a limited real right. The lessee's real right enjoys preference if it conflicts with any other subsequent vested right. Thus, if the right of a mortgage or servitude holder vests after that of the lessee's limited real right takes preference over the real rights subsequently vested. In addition to this, the right of the lessee is preferred to purely personal rights irrespective of the time when they were vested. Thus, non-preferent creditors to the lessor are always bound by the lessee's limited real right. The effect of the lessee's limited real rights is that the successor cannot disturb him or her in the exercise of the rights in terms of the lease. In respect of the alienation of the leased property, the question arises whether the new owner will, apart from having to allow the lessee to continue in his or her control, also take over from the original lessor the rights as creditor and the duties as debtor in terms of the lease contract. In accordance with the general principles of the law of contract, it is not possible for the new owner to take over the rights and duties without following the prescribed rules for the cession of personal rights and delegation of duties. Personal rights or claims are transferred by cession and duties by delegation or novation. Therefore, in principle, the new owner must tolerate the lessee's exercise of his or her real rights, but this does not mean that the new owner simultaneously takes over the rights and duties of the lessor. However, the courts have taken a different view of the matter. It has been held that as soon as the new owner has taken transfer as owner, he or she is entitled to rent, and further, that the seller, by alienating the property, releases him or herself from the contractual duties created by the lease contract. These duties now vest on the buyer. This was clearly stated by Chief Justice Corbett in Jenna Way Properties Proprietary Limited versus Mediotronics Natal Proprietary Limited, 1995. In terms of our law, the alienation of leased property consisting of land or buildings in pursuance of a contract of sale does not bring the lease to an end. The purchaser, the new owner, is substituted ex lege for the original lessor, and the latter falls out of the picture. On being so substituted, the new owner acquires by operation of law all the rights of the original lessor under the lease. At the same time, the new owner is obliged to recognize the lessee and to permit him to occupy the leased premises in terms of the lease, provided that he or she, the lessee, continues to pay the rent and otherwise to observe his obligations under the lease. The lessee, in turn, is also bound by the lease, and provided that the new owner recognizes his rights, does not have any option or right of election to resile from the contract. This is the impact of hier gaat voorkoop in our modern law. That is our emphasis. The buyer is therefore bound by all the terms of the lease. If the actual terms of the lease differ from the apparent terms, for example, where a lease which is in writing has been amended orally, the buyer is bound by the actual terms. The lessee has no right on a change in the person of the lessor, that is, where the lessor sells the premises and the purchaser becomes the new lessor, to elect whether he or she wishes to continue with the lease or not. And then you can just do that activity on your own time. PVL3701, Property Law, Study Unit 13. Constitutional Property Law. Number 1. Introduction. Up to now, we have concentrated in this module on the law relating to things, ownership, and limited real rights. You have learned, for example, what things are and how ownership and limited real rights to things are acquired and protected. However, the Constitution of the Republic of South Africa, 1996, compels us to broaden our view of the law of things to include a discussion of property. For constitutional purposes, therefore, we have to take a fresh look at the concept property. One of the aims of the Constitution of 1996 is to recognize fundamental human rights. One fundamental right which is important in the law of things is the right to property, as protected by Section 25 of the 1996 Constitution, recognized as the Property Clause. This study unit deals with the first part of the Property Clause, namely Sections 25, subsections 1 to 4. The main issues to be addressed with regard to Section 25, subsections 1 to 4 are the following. Firstly, what is property? Secondly, what is a deprivation? And lastly, what is an expropriation? The second part of the Property Clause, that is, Section 25, subsections 5 to 9, deals mainly with land reform, which is discussed in the next study unit. Number 2. Property Clause. Section 25, the Property Clause, reads as follows. Property. Number 1. No one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property. Number 2. Property may be expropriated only in terms of law of general application. A. For a public purpose or in the public interest. And B. Subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to by those affected or decided or approved by a court. Number 3. The amount of the compensation and the time and manner of payments must be just and equitable, reflecting an equitable balance between the public interest and the interest of those affected, having regard to all relevant circumstances, including A. The current use of the property. B. The history of the acquisition and use of the property. C. The market value of the property. D. The extent of direct state investment and subsidy in the acquisition and beneficial capital improvement of the property. And E. The purpose of the expropriation. 4. For the purposes of this section, A. The public interest includes the nation's commitment to land reform to bring about equitable access to all South Africa's natural resources, and B. Property is not limited to land. Number 5. The state must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access to land on an equitable basis. Number 6. A person or community whose tenure of land is legally insecure as a result of past racially discriminatory laws or practices is entitled, to the extent provided by an Act of Parliament, either to tenure which is legally secure or to comparable redress. Number 7. A person or community dispossessed of property after the 19th of June 1913 as a result of past racially discriminatory laws or practices is entitled, to the extent provided by an Act of Parliament, either to restitution of that property or to equitable redress. Number 8. No provisions of this section may impede the state from taking legislative and other measures to achieve land, water, and related reform, in order to redress the results of past racial discrimination, provided that any departure from the provisions of this section is in accordance with the provisions of Section 36, Subsection 1. And number 9. Parliament must enact the legislation referred to in Subsection 6. Number 2.1. Meaning of property in terms of Section 25. When a person alleges that his or her right to property has been infringed, it must be determined what constitutes property for constitutional purposes. The object of constitutional protection is wider than the traditional private law category of corporal or tangible things. Not only are ownership and limited real rights granted protection, but presumably also a number of other rights such as shares, immaterial property rights, for example, copyright in a book, traditionally neglected property rights such as customary land rights and so-called new property rights, for example, rights against a pension fund, and labor rights, for example, the right to belong to a union. In recent judgments, the Constitutional Court confirmed the following were property for the purpose of Section 25. Number 1. A commercial trading license allowing the sale of wine in a grocery store. And number 2. A personal right to recover money paid for goods delivered in terms of Section 89, Subsection 5C of the National Credit Act, number 34 of 2005. The wide interpretation of the term property accords with widely accepted constitutional practice, in terms of which property is given an extensive interpretation to include a diversity of rights. The Constitutional Court in First National Bank of South Africa Limited, or Westbank, versus Commissioner for the South African Revenue Services and another, or First National Bank of South Africa Limited, that is Westbank versus Minister of Finance, 2002, at paragraph 51, examined the content of Section 25 and specifically the meaning of property, and stated that, at this stage of our constitutional jurisprudence, it is practically impossible to furnish and judicially unwise to attempt a comprehensive definition of property for purposes of Section 25. It is sufficient to hold that ownership of a corporal movable must ownership of land lie at the heart of our constitutional concept of property, both as regards to the nature of the right involved as the object of the right, and must therefore, in principle, enjoy the protection of Section 25, which is our emphasis. Number 2.2. Deprivation. The term deprivation is misleading or confusing because it can create the erroneous impression that it always refers to the taking away of property, whereas in fact deprivation is distinguished from the narrower term expropriation. It is therefore important to understand that deprivation does not necessarily refer to the taking away of property. Synonyms for the word deprivation are regulation, limitation, and restriction. In sense, any interference with the use and enjoyment of private property involves some deprivation with regard to the person who has a right to or in the property concerned. In this sense, deprivation refers to interference in the wide sense, whereas expropriation refers to interference in the narrow sense. Expropriations are therefore a subspecies of deprivations. Remember that Section 25, Subsection 1, which deals with deprivations, reads as follows. No one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property, which is our emphasis. A deprivation is the exercise of a state's policing power, that is, its ability to regulate the use of private property by restricting an owner's exercise of his or her entitlement as owner. Normally, the state does not pay compensation for a deprivation. Examples would be limitations in terms of land use, planning, developmental and environmental conservation legislation. And then there's an example. S sells a part of his farm to Z, a developer who wants to develop the land as a township. After Z has obtained permission for the development, he lays out the area in terms of township establishment legislation as Newtown Extension 1. Newtown Extension 1 consists of 30 stands of 500 square meters each. Against the title deeds of each of the stands in Newtown Extension 1, a condition is inserted which provides that only a single residential dwelling house may be erected on the stand. The following two requirements have to be met for a deprivation to be valid. Firstly, a deprivation must take place in terms of a law of general application. Deprivations of property usually occur as a result of a statutory provision. And secondly, a deprivation of property may not take place arbitrarily. In First Rand Bank of South Africa Limited or Westbank versus Commissioner of the South African Revenue Services or First National Bank of South Africa Limited or Westbank versus Minister of Finance 2002, the court concluded that a deprivation of property is arbitrary when the law that is referred to in Section 25 does not provide for sufficient reason for the deprivation or limitation, or if it is procedurally unfair. Number 2.3. Expropriation. Expropriation of property in terms of Section 25, Subsection 2 of the 1996 Constitution results in the legitimate imposition of limitations that involve the actual taking away or acquisition by the state of private property. Compensation is always payable. Normally, it is said that the state can legitimately expropriate private property for public use of the property to facilitate the state's functions and duties in the public interest. This is most often illustrated with reference to the building of public facilities like roads and dams. An expropriation of property will be valid if: number 1, it takes place in terms of a law of general application, for example, in terms of a statute. Or number 2, it is for a public purpose or in the public interest. The terms public purpose and public interest have different meanings, but they are usually interpreted with reference to a public purpose that is clearly not a purely private interest, but one that falls somewhere in the range between mere public benefit, something that will benefit the public in some way, and strict public necessity, something that is absolutely necessary for public safety, etc. And lastly, compensation is paid. The amount and the time and manner of payment must be determined by the parties affected by the expropriation or should be decided or approved by a court of law. There are specific provisions regulating the payment of compensation. We can see that in Section 25, Subsection 3 of the Constitution. The court has a discretion to determine the amount of compensation payable, taking the factors in Section 25, Subsection 3 and other relevant circumstances into account in each individual case. The Expropriation Bill of 2015 will once it is enacted, also affect how compensation is calculated. In this study unit, we touch only superficially on this very important issue. Consult the textbooks in the bibliography for further explanation and expansion on the topic. And then you can just study the activity on your own time, which is quite extensive. And then we can move on to study unit 14, Land Reform. Number 1, Introduction. Land reform forms an integral part of the transformation process in South Africa. Land reform can be divided into three main categories: redistribution of land, as per subsection 5, land tenure reform, as per subsection 6, and restitution of land rights, as per subsection 7. Each of these categories is discussed briefly below with reference to the constitutional directive for each category, its function, and some of the initiatives taken by the government to achieve the objectives of each category of reform. And then there's a small activity. Number 2, redistribution of land. Number 2.1, Introduction. Section 25, subsection 5 of the Constitution 1996 provides the following. The state must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access to land on an equitable basis. For the purpose of establishing a more equitable distribution of land, government was authorized by subsection 25, subsection 5 of the Constitution 1996 to rectify a general state of affairs, namely the unequal distribution of land. Redistribution of land is the process of making land or access to land available to people who have never had land or who had insufficient land. The state has taken various legislative and other measures in the form of statutes and state programs to attain this goal. The statutes include, among others, the Provision of Land and Assistance Act No. 126 of 1993, the Spatial Planning and Land Use Management Act No. 16 of 2013, Spluma, and the Land Reform Labour Tenants Act No. 3 of 1996, and the Extension of Security of Tenure Act No. 62 of 1997. We discuss only two of these acts briefly below. Number 2.2, Provisions of Land and Assistance Act No. 126 of 1993. The legal basis for redistribution is provided by the Provisions of Land and Assistance Act No. 126 of 1993. It authorizes the Integrated Program of Land Distribution and Agricultural Development, LRAD, and the Settlement and Land Acquisition Grant (SLAG) programs, whereby advances or subsidies are granted to persons who have no land or who have limited access to land and who wish to gain access to land or additional land. Number 2.3, Spatial Planning and Land Use Management Act No. 16 of 2013. Another measure to achieve the objective of the redistribution of land is spatial planning and the management of land use. What is spatial planning and land use management, you may ask? It refers to the processes and laws regulating the planning for and management of the development of spaces, both urban and rural. During the apartheid years, planning laws were used to exclude certain persons from certain areas and prevented these persons from owning or having access to other rights to land. A plethora of both national and provincial legislation resulted in an uncoordinated, fragmented, and discriminatory system of land use and management. These spatial injustices are now addressed in the National Framework Act. Spatial Planning and Land Use Management Act No. 16 of 2013, Spluma. It came into force on the 1st of July 2015, putting in place a single uniform spatial planning and land use management system. Spluma also repealed the following national legislation: the Removal of Restrictions Act number 84 of 1967, the Physical Planning Act number 88 of 1967, the Less Formal Township Establishment Act number 113 of 1991, the Physical Planning Act number 125 of 1991, and the Development Facilitation Act number 67 of 1995. The objectives of Spluma, as enunciated in Section 3, are to provide for a spatial planning and land use management system, which promotes social and economic inclusion, redresses the imbalances of the past, and ensures equity in the application of spatial development, planning, and land use management. In order to achieve these objectives, Spluma provides for 5 development principles to be applied to spatial planning and development and land use management. Number 1. Spatial justice, as per Section 7, Subsection A. Number 2. Spatial sustainability, as per Section 7, Subsection B. Number 3. Efficiency, as per Section 7, Subsection C. Number 4. Spatial resilience, as per Section 7, Subsection D. And lastly, good administration, as per Section 7, Subsection E. These principles are based on the constitutional values provided for in Section 24 of the right to have the environment protected. Also, Section 25, the protection of property rights and promotion of land reform. Also, Section 26, the right to access to adequate housing. And Section 27, Subsection 1b, the right to sufficient food and water of the Constitution. The significance of the principles lies in the fact that they must guide the preparation, adoption, and implementation of any spatial planning and development instrument, as well as any decision-making in terms of Spluma, as per Section 6, Subsection 1. The principle of spatial justice is of special importance in the context of expanding access to both rural and urban land. The components of this principle can be summarized as follows. Number 1. Past spatial imbalances and exclusions must be redressed. Secondly, people and areas previously excluded must be included. And lastly, informal areas and settlements must be upgraded. Then you can just study that activity on your own time, and then we go on to number 3. Number 3. Land tenure reform. Number 3.1. Introduction. Section 25, Subsection 6 of the Constitution of 1996 authorizes land tenure reform by providing as follows. A person or community whose tenure of land is legally insecure as a result of past racially discriminatory laws or practices is entitled to the extent provided by an Act of Parliament either to tenure which is legally secure or to comparable redress. This category therefore applies to people who do have access to land or housing tenure, but whose tenure is based on weak or insecure property rights. The purpose of land tenure reform is to give legal recognition and protection to weak and insecure rights. This process involves the introduction of legislation and other measures to improve the quality and security of existing land rights. Several statutes have been introduced to improve weak and insecure rights, namely, Number 1. The Upgrading of Land Tenure Rights Act, number 112 of 1991. Secondly, the Communal Property Associations Act, number 28 of 1996. And thirdly, the Communal Land Rights Act, number 11 of 2004. The Communal Land Rights Act has, however, been declared unconstitutional in Tongwane versus National Minister for Agriculture and Land Affairs in 2010 and was never implemented. This process also involves the protection of certain categories of persons from eviction by ensuring that certain procedures must be followed before they can be evicted. This is authorized by Section 26, Subsection 3 of the Constitution of 1996, which provides that no one may be evicted from their home or have their home demolished without an order of court made after considering all the relevant circumstances. No legislation may permit arbitrary evictions. Statutes such as the Land Reform or the Labour Tenants Act No. 3 of 1996, the Extension of Security of Tenure Act No. 62 of 1997, and the Prevention of Illegal Eviction from Unlawful Occupation of Land Act No. 19 of 1998 provide requirements and procedures which must be complied with before an occupier or user may be evicted. We briefly discuss these three statutes below. Number 3.2. Land Reform or Labour Tenants Act No. 3 of 1996. This act is aimed at regulating the position of labour tenants. In terms of this act, a labour tenant is a person who has the right to reside on a farm and also has the right to use the land for cropping or grazing in return for his or her labour. The substantive part of a labour tenant's remuneration consists of the right to occupy and use the land. The Act provides for the security of tenure of labour tenants and those persons who occupy or use land as a result of their relationship with labour tenants. In addition, a labour tenant can only be evicted in terms of a court order. A court will make such an eviction order if it is just and equitable to do so after the labour tenant has refused or failed to provide labour to the owner despite one calendar month's written notice to resume work, or if the labour tenant has committed such a material breach of the relationship between him or herself, and the owner that it is not practically possible to remedy it. Number 3.3. Extension of Security of Tenure Act, number 62 of 1997. This act applies to occupiers, that is, people occupying land unlawfully. In terms of the Act, an occupier is a person who resides on land which belongs to another person, and who has permission or another right in law to do so, but excluding a person using or intending to use the land in question mainly for industrial, mining, commercial, or commercial farming purposes. The Act applies to rural areas only. The security of tenure of occupiers is promoted by regulating the conditions and circumstances under which the right of persons to reside on land may be terminated. An occupier's right of residence may be terminated on any lawful ground as long as the termination is just and equitable, having regard to certain factors. The Act also provides that the rights, duties, and legitimate interests of the owners of the land should be recognized. Farm workers who occupy land with the permission of the landowner are protected against unlawful eviction by the provisions of the Act. A farm worker is a person who performs work similar to that of a labour tenant, but who is remunerated predominantly in cash. ESTA was enacted to give effect to Section 26, Subsection 3 of the Constitution, which aims to protect a person against eviction from his or her home without a court order, made after the relevant circumstances have been considered. In considering the eviction of an occupier, the courts will therefore balance the opposing interests of the landowner and the occupier. The common law is subject to the provisions of ESTA, and a landowner will only be able to evict an occupier in terms of a court order obtained under ESTA or ESTA, I guess. And then there's an activity which you can do on your own time. And then number 3.4, Prevention of Illegal Eviction from and Unlawful Occupation of Land Act number 19 of 1998, or the PI Act. This act differs from the Extension of Security of Tenure Act No. 62 of 1997 because it protects people who occupy land unlawfully, in other words, people who occupy land without the permission of the landowner. The act was enacted to give effect to Section 26, Subsection 3 of the Constitution. The purpose of the Act is to provide for procedures to evict unlawful occupiers, the principle being that nobody may evict an unlawful occupier of land without the authority of a court order. A part of the eviction process of unlawful occupiers is that certain circumstances must be considered before an unlawful occupier may be evicted. These circumstances include the rights and needs of the elderly, children, disabled persons, and households headed by women, and in certain cases, the availability of alternative accommodation for the relocation of the unlawful occupier. In Port Elizabeth Municipality versus various occupiers in 2005, it was held that an eviction order must be just and equitable. Consequently, parties with competing interests must attempt to reach an agreement through discussions and/or mediation. If parties cannot reach an agreement, the court may, considering all relevant circumstances, grant an eviction order. And then there's another activity which you can do on your own time. Number 4. Restitution of land rights. Number 4.1. Introduction. Section 27, Subsection 7 of the Constitution 1996 authorizes the land restitution process and provides as follows. A person or community dispossessed of property after the 19th of June 1913 as a result of past racially discriminatory laws or practices is entitled to the extent provided by an Act of Parliament either to restitution of that property or to equitable redress. Restitution of land rights is aimed at returning specific pieces of land taken away from specific people during the apartheid era to those people. It is a restricted process because it only concerns specific pieces of land and specific people. Section 25, subsection 7, also restricts the process of dispossessions that took place after the 19th of June 1913. This process differs from the process of redistribution discussed above. Because land restitution is aimed at rectifying specific dispossessions that took place in the past, whereas land redistribution is aimed at rectifying the unequal distribution of land in general. Section 25, subsection 7 authorizes Parliament to promulgate an act for the restitution process. The statute dealing with such restitution is the Restitution of Land Rights Act, number 22 of 1994. The Act initially provided that claims could only be instituted up to the 31st of December 1998. In terms of the Restitution of Land Rights Amendment Act, number 15 of 2014, claims can be submitted again until the 30th of June 2019. The Constitutional Court has, however, declared the Amendment Act unconstitutional because proper consultation did not take place before the passing of the Act. Parliament has until July 2018 to rectify and re-enact the Act. Okay, then we move on to 4.2. Restitution of Land Rights Act 22 of 1994. A person is entitled to restitution if land was taken away after the 19th of June 1913 as a result of past racially discriminatory laws or practices. Such a person will, however, not be entitled to restitution if just and equitable compensation was received at the time of the dispossession. After considering a claim, the Land Claims Court can make different restitution orders. Some of these orders include: number 1, restoration of land, a portion of land or any right in land. Number 2, grant by the state of an appropriate right to alternative state-owned land. Number 3, payment of compensation by the state. Number 4, inclusion of the claimant as a beneficiary of a state support program for housing or the allocation and development of rural land. And number 5, grant of alternative relief. For several reasons, it may not be possible or desirable to return a specific piece of land to the claimant. For example, if the piece of land has been developed into an office block or a shopping center, or if the piece of land is occupied by another group of people and dispossessing them would be unjust and inequitable. It is also possible for a court to order that additional compensation be paid in a case where inadequate compensation was paid to the claimant at the time of the original dispossession. And then we move on to Study Unit 15, Additional Forms of Statutory Land Use and Revision. Number 1, Introduction. So far in this module on the law of things, we have discussed the following real relationships to land. Ownership of land, lawful occupation, holdership of land, and land use driven in terms of the Constitution. In this study unit, we take a brief look at other forms of statutory land use. It is important that you determine the nature and content of the rights which are granted in terms of the statutes discussed below. We discuss the Sectional Titles Act number 95 of 1986, the Share Blocks Control Act number 59 of 1980, the Property Time-Sharing Control Act number 75 of 1983, and the Housing Development Schemes for Retired Persons Act number 65 of 1988. Number 2. Sectional Titles Act number 95 of 1986. This act provides for the division of buildings and the land on which they stand into sections and common property. It also makes provision for the acquisition of separate ownership of sections together with co-ownership of common property, which jointly make up a unit which is the object of the sectional title ownership, which equals the real right. A unit consists of a section, a defined part of a building such as a flat, garage, office or shop in a building, office block or business complex, together with an undivided share in the common property, which is the land and all permanent structures on the land that do not form part of a section, apportioned according to the participation quota. Ownership and co-ownership still form the basis of sectional title ownership. To facilitate this kind of ownership, certain common law principles had to be amended by the Sectional Titles Act. The Act further regulates the control over certain rights connected with the separate ownership of sections and joint ownership of the common property, the transfer of ownership of units, and the registration of sectional mortgage bonds over and real rights in units, and the granting and registration of rights in and the disposal of the common property, as well as the creation of a body corporate to manage each sectional title scheme by way of rules. Okay, and then you can just study that activity. And then we move on to number 3. Share Blocks Control Act number 59 of 1980. This act regulates the operation of share block schemes and provides for related matters. In terms of this legislation, a shareholder in a share block company acquires a personal right, that is, a creditor's right or claim, to use part of a particular building, that is, a flat, office, or shop, or a piece of land according to his or her shareholding. The share block company can be the owner or lessee of the relevant building or land. The object of the shareholder's right is therefore not an independent, immovable thing, but he or she has a personal right against the company based on his or her shareholding, to which the right to use a specific part of the building or land for a specific period is linked. The principles pertaining to sectional titles and share blocks are applicable to both property, time sharing, and housing development schemes for retired persons. Okay, and then there's a short activity, and then we move on to 4. Property Time Sharing Control Act number 75 of 1983. This act regulates the alienation of property time-sharing interests pursuant to property time-sharing schemes and related matters. In terms of these schemes, a person acquires a right or interest in the exclusive use or occupation of accommodation during determined or determinable periods during every year. The nature of the right depends on the form of the relevant scheme. A property time-sharing scheme can be established either as, number 1, a sectional title scheme in terms of the Sectional Titles Act number 95 of 1986 as a real right, or number 2, a share block scheme in terms of the Share Blocks Control Act number 59 of 1980, which is a personal right. Number 3, membership of or participation in a club which operates a time-sharing scheme, which is a real or personal right. And lastly, any scheme, measure, or undertaking declared by notice in the Gazette to be a time-sharing scheme. And then number 5, Housing Development Schemes for Retired Persons Act number 65 of 1988. This act regulates the alienation of certain interests in housing development schemes for retired persons and related matters. The act provides for the acquisition of a right of occupation in relation to immovable property in terms of a housing development scheme which confers such rights on retired persons in terms of either ownership or a personal right, that is, a creditor's right. The following types of housing development schemes can be established. Number 1, a sectional title scheme in terms of the Sectional Titles Act number 95 of 1986, which is a real right. Number 2, a share block scheme in terms of the Share Blocks Control Act number 59 of 1980, which is a personal right. Thirdly, membership of or participation in a club which manages a housing development scheme, which is a real or personal right. And lastly, a registered long-term lease, which is a limited real right. Please note that a housing development scheme for retired persons cannot take the form of a time-sharing scheme. And then there's just a last activity which you can do on your own time.